Okay, good afternoon, everyone. Thanks for taking the time out for this today. So we'll be talking about insurance distribution and providing some guidance specifically for your law firm today, actually. So just going to introduce you to the two main voices you'll hear today. So firstly, myself, I'm Anthony O'Hanlon. I'm the head of customer development at CLSQ. So my background is in learning and development. I've got 16 years in this particular industry supporting law firms. But our main speaker today is Tracey Calvert. Tracey is the regulatory compliance specialist at Oakalls Consultancy. And then just to give you a little bit of bio info on Tracey, Tracey is the immediate past chair of the International Bar Association's Professional Ethics Committee. That's easy for me to say. Tracey is a lawyer and the director of Oakalls Consultancy. Tracey is also a board member of the Wilmington Group's Legal Compliance Association and the Law Society's Legal Compliance Bulletin. And Tracey's also previously been employed by the Law Society and the SRA as well. So hopefully from that, what you'll get is that we've got someone who's really experienced in this area and give you some really good, solid information. So I'm just going to give you a brief introduction. And then I will hand over to Tracey, who will take you through the bulk of the content for this session. I will sort of drop back in on occasion to do some live polls. Now, normally we do those with smartphones. Don't know how many of you in the room have got your smartphones. If you have, you can take part. If you haven't, we can do verbal responses if you wish, so we can be flexible how we run those. In terms of the agenda then, so I'll say brief introduction from me, and then Tracey will take you through some definitions, what are insurance distribution activities, the legal framework around IDD, the role of the FCA, the SRA requirements, and then we'll finish with some myths around IDD. I'll then come back at the end just to explain a bit more about how CLSQ can help. And then we should have a good amount of time towards the end, a good 15 minutes so for any questions that you may have. Okay, so firstly, who are CLSQ? So you may know us as CLS. We rebranded just towards the latter part of last year. So we are the leading provider of data, technology, and insurance services. Obviously, work in partnership with InfoTrack, and thanks to InfoTrack for putting on this session today. So we provide legal indemnity and estate administration products and services for law firms. I've been working with law firms for 13 years. We have over 60 indemnity policies and also bespoke policies available. We have AA- rated capacity, which basically means we have really good capacity to handle claims and process claims. And we have a world-class net promoter score for our customer service. So why did we commission this research on IDD? And I think the fact you're all here today probably explains it. So there's really a lack of information, support and training out there on IDD. And we certainly noticed from speaking to law firms over the years that there was a certain amount of confusion in the marketplace regarding the requirements of IDD. As I say, limited training and support available, and a general maybe lack of awareness, certainly around the consequences of non-compliance. So with that in mind, rather than attempt this research ourselves, we wanted to get some experts involved, and I'm glad to say we've got one of them with us today. So we commissioned two independent compliance companies, one of which is Oakalls. Our goal was to get objective, independent and expert guidance on IDD. And actually we're going to share that research with you today as much as we can in a kind of 40-45 minute webinar. So with that in mind, I will hand you over to Tracey, and Tracey will start off just by giving you the context and the background to IDD. So over to you, Tracey.
Thanks, Anthony. Afternoon, everybody. Yeah, for me, it's been a real pleasure to be involved in this research. Ant mentioned that I worked previously for the Law Society and the SRA. And when I was working with them, I was one of their lead people thinking about financial services, right from the pre-Financial Services and Markets Act days through to about 2011. That's when I left. And I know that this is a really important regulatory topic. And I also know that there has been very little guidance out there to help all of us get it right. And it's one of the subjects where we have to be 100% right because not only will we upset our own regulatory body if we get this wrong, we're also going to be breaking the law if we get it wrong. And for you, you've got the extra interest of the FCA looking at you and making sure that because you're an authorized person as a firm, are you doing financial services in a way that satisfies them, or if we're going to jump over to the SRA world, satisfies the SRA as well. You've got two regulators looking at you and what you're doing. So it's really good to be able to spend the time with you this afternoon to discuss all of this. And let me start right at the beginning with just a reminder about what we're talking about with insurance distribution activities. They're defined in law as the activities of advising on, proposing, carrying out work preparatory to the conclusion of contracts of insurance, of concluding contracts, assisting in the administration and performance of such contracts, and so on. So very legalistic language. For us, I would say we should just think whenever we arrange insurance, whenever we might make a recommendation about insurance, then we need to think about financial services. And we're going to be carrying out those activities in various different ways for clients. If I think of conveyancing, might be arranging a defective title or lost deeds insurance, products for sellers. In litigation, it might be after the event insurance. In estate administration, it's going to be missing beneficiary or empty property, or even just property insurance, and it goes on and on. And the point to note is that we're doing it subject to very restrictive legislation. This topic comes from the Insurance Distribution Directive. That's EU legislation which we have retained in this country. Financial services more generally are part of a very restrictive regulatory framework. So if we get it wrong, there's all sorts of consequences. And the whole reason for this framework and this rigidity is because of the risks to consumers from mis-selling or being advised by businesses where there are no repercussions for bad behaviours. By necessity, the restrictions on who can provide services in this world and the consequences of bad selling or bad involvement in this world is very severe. So if I can get Anne to move on to the next slide for me. Thank you. A little bit more about the legal framework. Financial Services and Markets Act 2000, FSMA. I don't know whether you've read it. If you haven't read it, I wouldn't advise you to read it. It's the most awful piece of legislation in my mind because it's so detailed. What we need to know is that it's the principal piece of financial services legislation that's got to be taken into consideration by anyone undertaking insurance distribution activity in the UK. And that's because FSMA creates the current regulatory framework for the provision of financial services. And this is what restricts service providers, including lawyers, when it comes to insurance distribution activities. And in particular, we have to make sure that we're not in breach of Section 19 of FSMA, that's the general prohibition. It contains the requirement that anyone who's conducting financial service activities, including insurance distribution work, must either be authorized, and that's authorization by either the Financial Conduct Authority or the Prudential Regulation Authority, or be able to rely on an exemption. That's why it's called the general prohibition. And providing financial services without being authorized or exempt is a criminal offense. And there are such severe consequences for breaching this general prohibition. It's a really important compliance consideration for law firms. So it's always sensible to know who's keeping an eye on what we're doing within the firm. If we're FCA authorized, who is making sure that we're complying with that regulatory body's requirements? but overall, who's looking at service provision because it's a law firm providing the services, so that there needs to be compliance with aligned SRA duties as well. So on to the next slide. Thanks, Anne. The Financial Conduct Authority, as I said, it's one of two regulators with powers granted under FSMA. The FCA will be regulating financial services firms and financial markets in the UK. It replaced the Financial Services Authority about 10 years ago now. It works alongside the Prudential Regulation Authority, which is the regulator of the banks and the building societies and the credit unions and the insurance companies who produce and sell the products that we use for our clients. Now, you have decided in your firm that you want to be FCA authorized, and I'm assuming that's because of the type of work that you might want to do in a mainstream way. And that means that you're in a very small minority of law firms. You're duly authorized by the FCA and the SRA. Most law firms, a huge majority, have decided they don't want to provide financial services in a mainstream way, so they rely on an exemption under FSMA, which allows them to do limited services through what's known as the Part 20 exemption, the exemption for the general rule that you need to be authorized. So you're in a minority for this, and I presume it's because of the services that you want to provide for your clients. And for you, of course, it's all about being defined as an authorized person for these purposes and making sure that you can comply with the FCA handbook for that. And for you, of course, with that type of activity, you've got the FCA with the powers to supervise you and, if necessary, take enforcement action against you. So next slide, please, Anne. Thank you. The consequences of being FCA authorized are on this slide. Authorization with this regulatory body is subject to conditions that they will be testing you against. So you need to comply with the FCA handbook. As I've mentioned, they have oversight powers over you. The FCA also have a memorandum of understanding with the SRA. So the two regulators will regularly share intelligence about firms like you. And if the FCA were to supervise and find a problem, they talk to the SRA. And if you were to make a report to the SRA and they found out anything about you, which they thought has an overlap with financial services regulation, they would be talking to that body as well. But then, having said all of that, I think the important thing to really dwell on is the fact that even though as a firm you're an authorized person, because you are a professional law firm, there is a certain carve out from the FCA handbook that's available to you that wouldn't be available to other financial services companies. And that's going to entitle you to do what's known as non-mainstream regulated activities. And this is the language that's used for you instead of the language that's used for law firms that are only authorized by the SRA. They're not authorized by the FCA also, but they do what they call exempt regulated activities under the SRA's umbrella. For you, you can do very similar things under the SRA umbrella rather than the FCA umbrella, and they're called non-mainstream regulated activities. So the next slide, please. Thank you. There are various conditions that must be satisfied when you conduct non-mainstream regulated activities, and one of the most important is the way in which you handle commission payments. You need to be demonstrating you're complying with section 3323 of FSMA when you carry on non-mainstream regulated activities for the clients of your law firm and you receive a pecuniary reward. reward. You'll see the wording on this slide. What it means in reality is that you have to treat any commission which you receive as money that belongs to the client. And that money must be paid to the client unless the client's giving you informed consent to the firm keeping the payment. So in other words, you need to account to the client by informing them how much you have earned through whatever you have done for them. You must make it clear that the money belongs to them and they must agree to you keeping the amount in question. And if the client doesn't agree, well, then the payment has to be paid over to them. And this is a hot spot for both the SRA and the FCA, that you get this right, because what they don't want is for any client not to understand that they are giving their permission to you keeping any pecuniary reward like this. So any misleading language, any attempts to retain monies like this through seeking blanket consent in terms of business in very small print, well, is not going to satisfy the legal requirements in FSMA. And it's likely that the SRA would say that the lawyer involved has acted unprofessionally, has not acted in the best interest of their clients. If you move on to the next slide. Oh, over to you, Ant.
It is. You get a little break, Tracy. Thank you for
you.
that. Yeah, so at this point, we'll do a live poll now. Again, I don't know how many of you have got your smartphones hand. Possibly not many, because you've maybe left it at your desk, which is good practice. But yeah, when we normally run this, we online, we have people take part in these. I can still run this though, and you can maybe just verbally shout out what you think. So let me just switch to the polling site. 1 second. Okay, so a couple of questions, and the first one, and hopefully you can see it where you're sat. Which of the following are FCA enforcement powers with regards to IDD? So
you can't see that.
Can't see that. Right, let me try again.
Just look at your interactive smart.
Okay.
Screen.
Any better now?
Yes.
Yeah. Right. Okay. Yeah, so the first question is, which of the following are FCA enforcement powers for IDD? Let's say if you've got a phone to hand, you can, or a laptop even, you can put the code in, you can use the electronic method of answering. But to make it easier for you all, there's actually only one of those there which is not an FCA enforcement power. So does anyone want to stab at what that would be?
Bottom left.
Bottom left. You're so far away I can't see you, but whoever said that is absolutely correct. Yeah. Yeah, it's all of those are in fact legitimate enforcement powers, with the exception of the bottom left one, which would be, you know, immediate action without investigation. They'll always investigate first, but hopefully that kind of illustrates the scope of those enforcement powers, everything from withdrawn authorization, suspension, fines, to criminal prosecution. And then the next question, which is a more straightforward one: could an offence under FSMA result in contracts of insurance being unenforceable? And it's a yes or no, so you go 50-50 shot. Any thoughts?
Yes. Yes.
Yeah.
Yeah, got a bit of a consensus on yes. And that's correct. That is actually the correct answer. So yeah, under FSMA, if you've sold insurance, but you've not, you know, followed some of the key rules of IDD, it could mean that the insurance you've sold is, those contracts are unenforceable. So hopefully between those two, it gives you an idea of the seriousness of IDD and the importance of complying with it. Okay, so I will hand back to Tracy.
Thank you.
Okay.
Thank you. Yeah, and I think, again, to make the point about how serious this is, not only would it end up in a legal issue and the committing of an offence, the SRA have regulatory duties that they impose on us, saying that we must comply with the law. So get the law wrong, and then also it becomes a regulatory concern to them as well. I thought it would be helpful to have a little time to think more about the SRA's enforcement powers as well. Of course, in England and Wales, the SRA is the largest regulator of legal services. You know that it authorises and regulates solicitors, about 220,000 solicitors at the moment. It also has the power to authorise law firms like yours. It authorises about 10,000 law firms at the moment. Very significantly, the authorization of the law firm point means that it's got regulatory reach over absolutely everybody working in the law firm, not just the solicitors. And what I would say is one of the issues that might cause the SRA concern in this world is, are you employing people to provide insurance distribution activities to clients, and they haven't got the right competence to do that? They haven't got the right knowledge, skill sets, and what have you. Competency is very important to the SRA. They are actually this year undertaking a competency review, and they want to find out more about what we are doing to make sure that we all have the appropriate skill sets in our different firms. So for a firm like yours that is established as a financial services provider, they might well ask, what training have your staff had on these particular topics? And what they expect from you might well be different to what they expect from other law firms that aren't also FCA authorized. It has a lot of enforcement powers, as you know. You may or may not be aware that it's recently bolstered its fining powers. It has been granted the right to fine traditional law firms up to £25,000 before the matter needs to be referred to the Solicitors Disciplinary Tribunal. So if you are a traditional law firm, that's something to point out. If you're not, and you're an ABS, an alternative business structure, then I'll just say very quickly, you know that the SRA has the power to fine the firm £250,000 for the firm and £50 million for individuals within the firm. These fining powers are a tool which the SRA say they're going to use robustly so that they can deal with standards not being met and breaches of the rule book. And the rule book is, of course, the standards and regulations, the STARS, as they would like us to call them. In terms of financial services, there are two particular sets of rules that I'd flag up, one of which I need you to just discount immediately. And that's the scope rules. There's a set of rules that apply only to firms which are not also FCA authorized, and that's the scope rules. They don't apply to you because the FCA handbook is the substitute for you. But when you're doing your non-mainstream regulated activities, then it will be the case that another part of the rule book, the SRA Financial Services Conduct of Business Rules, the COB rules on this slide, they will apply to how you provide services in a non-mainstream way. So if I can move on to the next slide. Thank you, Anne. And in terms of doing the non-mainstream regulated activities, well, there are a lot of conditions attached to you providing services in this way. For example, you need to make sure that you're doing something which the law firm which wasn't FCA authorized could do as an exempt regulated activity. So you can't, for example, decide to become an insurer in your own right and offer your own insurance products using the non-mainstream exception, because that's just too sensitive and too mainstream. You have to account to clients for any commission. I've covered off that point. You have to make sure that when you are using the non-mainstream route, it's because what you are doing is a necessary bolt on to a current legal service. It's got to be complementary to the service that you are provided, and it's got to be incidental to the legal service. So, for example, you wouldn't be able to arrange after the event insurances for all and sundry. You couldn't go out and advertise, come to us, we will arrange after the event insurance for you, whether you need it or not, under the non-mainstream exemption. But what you could do is when you're doing dispute resolution, personal injury work, whenever a client who comes to you for those types of services needs to have a conversation about ATE insurance, needs for that to be arranged, then you can do it under this carve out from your authorization. And that's subject to compliance with those conduct of business rules that I mentioned. So if I go on to the next slide. Thank you. The only part of the conduct of business rules that isn't going to be relevant to you and you can't make use of is the status disclosure requirements. Most law firms have to comply with duties to tell their clients that they might do financial services, but they're not authorized by the FCA, that all complaints would go through the SRA schemes and so on. Clearly, that's not going to be the case for you. So you're not required to comply with the conduct of business rules in this specific circumstance, but you do have to give your clients information which complies with the FCA's rules on this. And you'll be doing that already, I know, in your terms of business and on your website and so on. Important that all your staff who are involved in insurance know what to do if they receive a complaint about financial services and how it's going to be handled. And then if I move on to the next slide, it's record keeping. In more detail, the conduct of business rules contain a number of record keeping and other duties that apply to your non-mainstream work. So it's things like keeping records of all the commissions, at least for 6 years, keeping a record of all the investment documents that you might keep for clients, giving clients details of your records of transactions and the basis on which you are dealing with the transactions. And this record keeping is necessary so that either the SRA can ask you for proof of what you've done, or also the FCA can ask you for proof of what you've done. And all those records have to be kept for at least 6 years. So I would expect that those records and all that information is all part of the privacy and data information that you're giving to your clients. In terms of client care, if I move on to the next slide, well, with client care, we're thinking about you and the safeguards that you'll be giving all your clients anyway. The SRA's rules and regulations are very onerous when it comes to making sure that clients understand what it is you're doing for them and making sure that they understand the advice that you're giving, making sure that they can then give you informed consent to next steps. It's all about making informed choices, in other way. And then to layer that up, the conduct of business rules takes information from the Insurance Distribution Directives and say, when it comes to talking about insurance products, information must be clear, fair, and not misleading. You must give information about whether you're an insurance intermediary or not, whether you're representing the client or the insurer or both, whether you've got an interest in an insurer or they have an interest in you. This is where law firms are partly owned by insurance companies, as is the case sometimes. And you've also, very importantly, got to give clients information about whether you're providing a personal recommendation or not. If I move on to the next slide, personal recommendations, I think this is one of the most risky issues to misunderstand, whether or not you're making a personal recommendation of an insurance product to your client And if you are, what information you have to give the client about the basis for making this recommendation. And for law firms undertaking a non-mainstream regulated activity, the position is explained in rules 10, 11, and 12 of the Conduct of Business Rules. And in respect of personal recommendations, I advise you to have this policy or whatever. You must provide your client with advice about whether you've given that recommendation, you're giving that bit of advice on the basis of a fair and personal analysis of their circumstances, and also whether you've got a contractual obligation to work with one or more insurance companies only, and if that's the case, the name of those businesses, or whether you haven't actually got any contractual obligations like that, but you're not giving advice on the basis of a fair and personal analysis of the whole insurance market, in which case you make that clear and you give your client the names of the insurers with whom you may conduct business or you do conduct business. And if you have made a personal recommendation on the basis of a fair and personal analysis, you've got to carry on giving information to the client. You've got to tell them the basis of your recommendation. Is it on a sufficiently large number of insurance products on the market? Has it been made in accordance with a criteria assessment of what's suitable for their needs? Has the client been given a personalized explanation about why a particular contract would best meet their needs? So if I move over to the next slide, I think I would just make the point that making a personal recommendation is not without compliance risks, not least because of the confusion that arises in connection with this concept, and also I think because of the trust that clients place in us when we're giving them advice. If a lawyer tells them to take out a particular insurance policy, a lot of clients will just expect that that is acting in their best interest, so we must be giving them something that is absolutely appropriate for their needs. So it isn't just a case of complying with all the information duties I've just mentioned. It's also, I think, a need to consider whether, firstly, you've got the necessary knowledge of both the client and the insurance product. Secondly, whether as an individual and as a firm, you have the right level of competency within the firm to make a personal recommendation. It's a skilled service after all. And whether you can show nonetheless that you're acting sufficiently independently and in the client's best interest. If you feel that that is too risky, because I do think it is a risky position to take, then you simply don't make a recommendation and you go back to the more preferable position in terms of risk of simply arranging a policy rather than making a personal recommendation to the client. So I move on to the next slide, and I can stop for a moment.
Yeah, catch your breath. Yeah, so we've just got one more poll, although I won't put it out as a poll, more as something for consideration. Then I can actually share with you some research we conducted prior to running these webinars, which might be of interest, particularly around the question of personal recommendations. So bear with me one moment. Okay, so I'll just bring this up on screen. You'll be able to see it now. So like I say, no need to kind of answer this one at all. But
it's there now. We've got it.
Just a slight delay in coming up. Yeah, no need to kind of sort of verbally answer this now. More just for your kind of consideration. And these are really some of the key things you should have in place to feel confident that you're ticking all the main boxes for IDD. So it's the likes of making sure your correspondence is clear, fair, not misleading, ensuring you provide an insurance product information document. That should certainly be the case. That will be the case if for anything you order from ourselves. But also, are you able to provide clients information about the insurance product and actually talk them through an IPID as well? So rather than just supply them with the IPID, if they had any questions on that, do you understand the layout and can you talk them through it? And again, that's something we can help with. Demands and needs statement, that should also be supplied with the insurance policy. Tracey mentioned informing them of your complaints handling process. And then finally, and bearing in mind the SRA competency review, can you say with confidence that all your employees involved in arranging insurance have that necessary knowledge and training? And obviously today is a really good step in that direction in terms of starting to get a better understanding of IDD. So just something for consideration. It will form part of the slide deck, this, so you will have be able to reference that. So I'll take us back to the slides, Tracey. Oh, before I do actually hand back to you, Tracey, I just mentioned I want to share some research we did. So we put a poll out on LinkedIn, and we asked all our law firms, all the people who follow us, and anyone who wants to take part in the poll, do you make personal recommendations to your clients about which insurance policy to take? Now, bearing in mind everything Tracey's just covered on the risks associated with personal recommendations, this was the result we had. So majority said no, 62%, although 20% of law firms did say they do provide personal recommendations, and then a further 18% said, well, we sometimes provide it on a case-by-case basis. So, 38% at one time or another are providing personal recommendations, and all the extra due diligence and risk that comes with that. I would actually go further and to say I'd be pretty confident that some of those 62% actually are providing personal recommendations, even though they think they're not. They may use a disclaimer which says they're not providing a personal recommendation, but in some instances their behavior will actually point towards actually providing a personal recommendation. So it's definitely something to think about. And even though you may use a disclaimer for that, just do revisit all that criteria Tracey's taking you through, just to ensure that you're definitely not providing a personal recommendation if you're not intending to, and you are just arranging insurance.
Thanks.
That's you, Tracey.
Thank you. Yeah, and I would just pick up on that. And I think whether you think you are making a recommendation or not, if the client thinks that you are advising them, then that's a risky position to be in, because anyone who is looking at a complaint about mis-selling would want to see, was the client given very clear information about what you were doing for them? So I would like to see very clear language in those communications about, this is not a recommendation and I am arranging something for you, and that sort of clarity to help. I just want to pick up on a couple of things that Ant mentioned in that list of key topics. Demands and needs statements. Now, in all circumstances, regardless of whether or not you've made a personal recommendation in accordance with Rule 11, or whether you are simply arranging a policy without providing advice, you have to nonetheless provide a demands and needs statement before the contract of insurance is completed. And that's to comply with Rule 12 of the Conduct of Business Rules. My feeling is you're going to be familiar with this process. It's going to be language which is less personalized. It is simply statements, again, in clear, non-misleading language about what it is you need, what it is that meets your need. What you may be less familiar with are these competency requirements. They've been on a bit of a slow burner, I think, as far as the SRA is concerned, but given their interest now in competency, it may well be something that you need to address now, sooner rather than later, because employees undertaking insurance distribution activities must be competent. That's a requirement in the conduct of business rules. And it also comes from the IDD, the Insurance Distribution Directive. And the FCA has suggested that this includes having appropriate knowledge of terms and conditions of policies offered, appropriate knowledge of FSMA and how it applies to insurance products, how to assess a client's needs. It's also a requirement that both the owners of the law firm and employees of law firms that do this sort of thing must be of good repute, as the language says, which means that they must have clean criminal records, mustn't have been declared bankrupt. You shouldn't have any concerns about their character. Now, that sounds rather onerous, but actually it's not really that onerous in terms of what we're expected to do anyway. We're expected to do screening for AML purposes. The SRA expects us to know who our staff are. So it's just applying those considerations to this topic as well. So move to the next slide. As Ant mentioned, this insurance product information document, we don't draft these as lawyers, they're provided for us, but the important thing is that we make sure that this is given to the client and we're satisfied that the client understands what it is that they are going to be acquiring. Are we confident that we can explain any of these terms to our clients? Do we have the skills to support clients in their understanding of all of this? So in my view, I think it's a good compliance use of time to assess your compliance position. Major questions: are you safe from regulatory scrutiny? For you, that's SRA and FCA scrutiny. And these are my subjects for, or suggestions for, benchmarking questions. Are you clear that the language you're using is sufficiently clear? The ombudsman, the legal ombudsman, fined a law firm recently for the language they were using to explain complicated things to certain clients. They were writing letters that were full of legalese and Latin phrases for clients who were, English wasn't their first language, they were immigration clients. It'd be the same sort of principle here. These are complicated subjects. Are we making it clear enough to the clients? Have we given them all the prescribed information about the products we're either arranging or advising on? If we're using third parties, are we confident that they are the right third parties for our clients? Have clients been given all the prescribed information? Have they been given information about the complaints handling process and what applies if they're unhappy? And I can't stress enough this important point about competency and making sure people know what they're doing when they are helping people, clients, with insurance products. So before I hand back to Ant, let me just go back to this point about personal recommendations and just to knock on the head what I believe are a few myths about quotes and whether or not we need to get multiple quotes or whatever. For lawyers providing insurance distribution activities in accordance with the SRA rules, the most important thing is to demonstrate professionalism, and that extends to a duty to act with independence, to act in a trustworthy way, to show that anything you do for a client has been judged to be in that individual client's best interest. So I feel it's important to justify your actions on this basis and to show that clients are given all information necessary when asked to then provide instructions as to their next steps. And with personal recommendations, it is simply the requirement that clients are told the basis on which a decision has been made when you are advising a particular product, and whether or not this is on the basis of a fair and personal analysis and the types of insurance companies you have gone to. And there is no obligation at all to get multiple quotes. The obligation is to make sure that the client is understanding the basis of your recommendation. So I'll hand back to you, Ant, now.
Thanks for that, Tracy. So yeah, just a last few bits from me, and then we'll open up to any questions you may have. So really, how can we help? Obviously, there's been lots that we've covered in terms of things you need to do as a law firm. So what can we do to help you as someone who provides legal indemnity insurance? Well, in terms of appointing an individual at the firm who's knowledgeable, we provide training and support. We have our own what's called the CLSQ training academy. And we've actually got lots of information specifically around the Insurance Distribution Directive and all the research that's been conducted over the last year. I'd say there's no other provider who has that level of research and content. So along with obviously the webinar today and the slides in the webinar, we can give you all access to that as, as a firm that orders from ourselves via InfoTrack. In terms of ensuring you meet the client's needs, well, again, we're the only provider to offer the ability to bespoke your own quotes via our variable statements of fact. So that just goes back to that principle of making sure you meet the client's needs. You're not just agreeing to a standard set of statement of facts. You can actually change some of those individual statements according to the client's needs. In terms of demands and needs statement and the IPID, well, we provide both of those as standard on all policies, so you don't have to worry about that aspect. And then the final point, which Tracy stressed, is just ensuring the wider knowledge within the law firm. So again, we can provide access to our IQ Academy, and we've got hours of webinar content and lots of useful resources on IDD, one of which is a guide to IPID. So it explains all the different sections of the IPID, so you can relate that to your clients or even provide it onward to your end client. So the Academy itself, when you get access to it, and it's free to access, although you will need a login. If you go to the IDD section, and you'll have all of that documentation, on-demand webinars, short-form videos, articles, and so on. So hopefully you'll find all that content useful. And that brings us to the end of the session. So promised about 15 minutes. We've got maybe if the hours are cut off, we've got about 12 minutes or so. So yeah, really open it up to any questions you may have.
I'm really scared. Definitely silent. I know, Anthony, it's very InfoTrack, because obviously we use it for residential property. You use it,
yeah,
don't you?
Use it a lot.
Do commercial property, do you use InfoTrack much? You do. With policies? Do we all do any policies? Do we use other?
I'm not seeing people that are using the track policies, but
because we have a lot of different suppliers that like use, don't you?
Yeah.
So I think that's something we need to look at, because I know from discussions I've had with other law firms, part of the South Group, some firms have decided actually they're not getting involved in this, so they don't do any insurance, they pass it over to say to the client, you've got to get it, go away and sort it out. Because there doesn't appear to be some pitfalls. But is there other, do you do professional indemnity insurance? Sorry, not professional indemnity, personal injury, AT insurance for InfoTrack?
No, we don't do personal injury. I mean, the two sort of core product sets for us is legal indemnity and estate administration. So there'd be probably the two areas you could engage with us on.
Okay, so we might look at that for the guys around here, because Jennifer, who's here, so she does inheritance dispute work, don't you?
Yeah.
And also the litigation team, if they deal with any after the insurance. Not that we do that much, I don't think, in the team. Any other questions? They're really sort of, I worry that people don't understand this. I don't think they do within the firm. So the competency bit for me is the bit that I'm more worried about.
That was the bit I picked up on, actually, whether we need, I think, new staff to come in and everything.
Yeah.
A bit of training.
And do people understand, like, the importance of making sure that anybody that's given that insurance does it? They know why it's important to give the IPID and make sure, because we do some audits and they don't always go out to the clients, so we can't see them in to the clients. I know your team does it.
Yeah, we do. Having said that, I will actually
if you make a point of checking that, for example, it couldn't be read as if we're giving a personal recommendation. It may be that, for example, we could, we may want to tighten the language on that.
So that's a good point that's come up from Tracey.
Yeah, I think we had checklists that we used to use. I think it's always by the wayside. So I might need to. Yeah.
I'm conscious of in long reports and titles, we come across defects. I'll say something, I report to the client, I'll say, there's a problem here, we could look into it further, or you could go for an insurance solution, which is what people often do. Please let us know if you would like any further information on this, and I sort of stop there. And these things most people hardly seem to bother, but if they do come back and say, yes, tell us how you do the insurance, that's something to do everything else they need to do.
But we wouldn't give personal recommendation, no. But is our language when we're corresponding with them, does that cover that?
If it doesn't, then it must do. I mean, I'm sure people have said in the past, I've seen people saying we've obtained 3. I know we say 3 persons, it's not the magic bullet for everything, but nevertheless, we'd say we can't tell you which one to go with. In our experience, we've had these, we've used these firms in the past, and here are quotes. And our bit would be just to help them fill in what the actual insured risk is, because the clients may not know. So we do that, and we'd say we spoke to 3 insurers. Once they've done their demands and these things, and then say, and obviously they just go with the cheapest.
Tracey's that they just go with the cheapest.
Yeah, I'm going to apologise because I didn't hear all of that where you're sitting. So can you just, I can hear you, Cecilia, so can you just tell me what that was?
Yeah. So what, in our commercial property team, if something happens and they're doing their report on title, they'll say we've got a defect here, do it about it, we can sort the insurance out, that's another option. And then we'll get 3 quotes. We're not giving them specifically telling them which one to go for. We leave it them to pick, but invariably they go for the cheapest one. So.
Yeah, always, doesn't it? Yeah, and I don't think just getting that equals recommending. You are helping a client make a decision about a policy you are arranging for them, but it's so important to get that language right. We can obtain this information for you, we can arrange this policy, but we're not actually going to recommend it to you.
We need to have that wording,
So do you get 3 quotes then each?
Yeah, but if you're doing it through InfoTrack, I'm assuming because InfoTrack, we're relying on InfoTrack to have, gone through, made sure that the people that they're obtaining insurance from is okay, aren't we?
Absolutely.
So we're not getting multiple quotes, we're just saying you need this insurance, there you go. Aren't we?
Yeah, for Resley we are,
So again,
so does that come with a personal recommendation?
Again, sorry, my apologies, it kept on cutting out, but I think a personal recommendation would be you either by implication or directly saying, I advise you to have this policy. If you make it clear that you're not advising a person to have a particular policy, I think then you can fall back on that. I can arrange a policy for you, and the information about the policy will be the more general information that you put into the demands and needs statement, which has to be given to all insurance clients wanting insurance products.
My worry, so you can hear me, Tracey, but my worry with that is if you say to a client, I can, we found a problem for you and we think insurance is the solution, and they say, yes, could you arrange it for us? And we say, we will get information. If we then just say, we just have one thing, and we'll say, we've told them they need insurance, they've agreed they need insurance, we've described the risk, and then we've just given them one quote. It's almost as if, well, what else would they possibly do? It's sort of that we're saying that's the one you've got to go for.
And I think with that, again, it would be in the communication. We can arrange this policy for you. Of course, there are other products available that you might want to find out about, but we can arrange this policy for you. And here's the demands and needs statement. This is why we think this is suitable for you.
Yes, it's strange. In personal injury, pretty much it isn't an open market. You basically need to be signed up with an insurer that you'll put all your insurance through. That's the way works because they like to have a basket of cases. Not many insurers, there are some, but generally they're not. Most insurers are not keen to, you know, for you to go between different insurers. So you kind of have to investigate, and then you make a decision. Well, they seem to be good, so that's who we. I mean, we haven't changed if we've gone onto, but so we're never going to be sitting around. Obviously, we'll need to make sure we're clear enough that we're not recommending it. This is what we happen to. We don't get commission for it, but this is we happen to arrange insurance for. There are other firms, but we can. It would be difficult for us to arrange. I mean, in theory, there probably are other providers we could go to on an ad hoc basis. It's very unlikely that they, but we don't know that they would offer us good terms because they're not getting any. They're not getting any bulk.
Is it worth doing, as Jeremy just a standard statement somewhere in our communication saying we do not receive any commission for this? I think that's a useful thing to say, isn't it?
Oh yeah, we say that.
Yeah, you say that already, don't you?
And I think what I'd suggest is a good compliance checklist is to have some sort of evidence on your file that the person arranging that policy in those circumstances has actually thought about this is appropriate for this client. This is why I'm going to just do what I normally do, which is speak with the normal insurer because I know that this will be in the client's best interest. And that is different to making a personal recommendation. That's more of your professional standard that's being applied to thinking about your client's best interests. What I think would be an issue is if you didn't have the audit trail to show that that being the thinking behind well, we're going for this policy in these circumstances.
Yeah. Any other questions? I'm trying to think what insurance you guys, what do you do?
It's mostly unoccupied property.
Unoccupied property. So where do you get your insurance from?
It's usually because.
Okay.
There were a few different trading names. I think there was like unoccupied direct. Yeah.
They're called as well, I think.
Yeah.
That's mostly
just probate VAs that deal with the insurance, right? It's mostly them, not really much part of the rest of the team.
Okay, so I think we've got a little bit of work to do at our end for sure. Just to make sure that we're up to speed, but I think that's definitely brought it home to me that I do worry that not everybody realises the implications if we're not doing everything as we should be doing it. And what I'm going to task these guys is go back to their teams, do a know-how session. We'll have the video recording available so that you can refer back to it and just make sure that anybody that's involved in doing this training, we get them to sit and listen and you get them to sign off to say that they have paid attention and they understand what they're doing. Okay.
Will you join us these trainings for a small
non-commission thing? But so we can refer back to the video, can't we? We can take some of the extracts of Tracey's like explanations for the various bits and pieces, and sort of just make sure that everybody's on the same page with it. Because so that's our difficulty, because we're regulated by both the FCA and the SRA, and we have we've got a debt collection team, so that's primarily why we're FCA regulated. But off the back of that, obviously that then catches our IDD stuff as well. So if we got rid of them, it'd be easier, I think. It's so onerous. But so if no other questions, no other observations from our panel up there. It was very useful. Thank you for organising it, Faye, and everybody else. Thank you, Tracey. Thank you, Anthony.
Thank you.
Your input.
And thanks to Anthony and Tracey as well for their knowledge and insights. It's very much appreciated. And I'll send the video recording over to you once it's wrapped up tomorrow, probably, Cecilia.
Okay. Thanks ever so much.
Bye-bye. Bye-bye.
Thank you, everyone.
Bye-bye.
Bye-bye.